Breaking Biafra agitations. IPOB leader Kanu'S sues Chief Judge of Federal High Court, Chief Registrar from Born Journalist, and public from terrorism trials. Welcome to the news and please subscribe to our channel. Some weeks ago, Justice Soho issued practice direction on trial of terrorism cases, noting that the distance and size of perimeter to be secured for the trial shall be determined based on the recommendation of security agencies on a case-by-case basis. Leader of the indigenous people of Biafra, Nnamdi Kanu, has sued the Chief Judge of the Federal High Court of Nigeria, Honorable Justice John Soho, and the Chief Registrar of the Federal High Court. Some weeks ago, Justice Soho issued the practice directions on trial of terrorism cases, noting that the distance and size of perimeter to be secured for the trial shall be determined based on the recommendation of security agencies on a case-by-case basis. It means terrorism trials, including the ongoing trial of Nnamdi Kanu and other related ones, will be done secretly, even without journalists, except the judge overrules otherwise. Kanu's trial by the Nigerian government, which continued on April 8th, was the first casualty of the new directive. In an originating summons with suit number FHC ABJCS 550/2022, which was filed on Monday, April 25th, Kanu's lawyer Ifeanyi Ejiofor sought answers to whether the powers conferred on the first defendant, Soho, includes power to make decisions for regulating trials of terrorism offences and the Federal High Court, considering the provisions of Section 36(1) and 36(4) A and B of a 1999 Constitution of the Federal Republic of Nigeria as amended. Ejiofor argued that the said practice directions were issued without the approval of the Federal Executive Council, formerly the National Council of Ministers of the Federal Government of Nigeria. The lawyer said the IPOB leader was not afforded any hearing before the said directions were made by Justice Soho. He further urged that his client, Kanu, against whose interest the said directions were primarily made, has already been publicly tried and condemned by the Federal Government of Nigeria and her Attorney General. That I know as a fact that it's in the interest of justice and fair hearing that the plaintiff, who has been so tried and condemned publicly by his accusers, enjoys a public trial, devoid of restrictions contained in the practice directions, he added. He also noted that the practice directions apply to affect the proceedings in charge number FHC ABCL 383/2015 pending before Honorable Justice Binta Nyako of Court Number 2, Federal High Court Abuja, in which the plaintiff is being prosecuted under the Terrorism Prevention Amendment Act. Ejiofor further urged the court to restrain the defendant and the agent from applying and enforcing the provisions of the Federal High Court practice directions on trial of terrorism cases 2022. Other relief sought include a declaration that the provisions of all of the Federal High Court practice directions on trial of terrorism cases 2022 are already the subject of Section 36(4) A and B of the Constitution of the Federal Republic of Nigeria 1999 as amended, and consequently that the odious, inoperative, and outrightly ultra-vires the first defendant, invalid, null, void, and of no effect whatsoever. A declaration that the failure of the first defendant to first seek and obtain the approval of the Federal Executive Council or the National Council of Ministers of the Federal Republic of Nigeria prior to enacting the Federal High Court practice direction on trials of terrorism cases 2022 as required by the Section 44 of the Federal High Court Act renders the Federal High Court practice direction on trial on terrorism cases 2022 ultra vires, null and void. A declaration that Order 3, Rules 3B and D of the Federal High Court practice directions on trials of terrorism cases 2022, which respectfully empower a Federal High Court trying terrorism cases to receive evidence by video link and to receive written disposition of expert witness are inconsistent with items 23 and 68 of the exclusive legislative list, as well as paragraph 2b of part 3 of the second schedule to the Constitution, which confers on the National Assembly the exclusive power to make rules of evidence, both substantive and adjectival, and are therefore ultra vires, null and void to the extent of the inconsistency. The declaration that the Order IV Rule of the Federal High Court Practice Direction on Trial of Terrorism Cases 2022, which provides that a person which contravenes an order or direction made under this direction shall be deemed to have committed an offence contrary to Section 34(5) of the Terrorism Prevention Act 2011, as amended, is odious and inoperative because the National Assembly had already covered the field VAT section 34(5) of the Terrorism Prevention Act 2011 as amended. A declaration that the rule-making powers of the first defendant under Section 254 of the Constitution of the Federal Republic of Nigeria 1999 as amended are limited to the premises of the Federal High Court and do not extend to outside its perimeters, which are under the exclusive responsibility of law enforcement agencies such as police, DSS, etc. Another of these honorable courts declaring the Federal High Court Practice Direction on Trial of Terrorism Cases 2022 unconstitutional, ultra vires, invalid, null, void, and of no effect. The defendants are expected to appear within 30 days after the service of the summons in them, inclusive of the day of such service, such an appearance to be entered for them to this summons which is issued upon the application of the above-named plaintiff for the determination of the following question. It was further noted that the dual both of a Federal High Court may appear by entering appearance personally or by a legal practitioner, either by filing for appropriate processes as in Order 7, in response at the registry of a court where that summons was issued, or sending them to that office by any of the methods allowed by these rules. Well. I don't know why they had to bring out that particular order or rule in order for trial of terrorism cases. Anything concerning this particular leader of the indigenous people of Biafra, they have been making things very, very difficult for him. And I've continued to say, I don't know what offense this man has committed. Whatever the offense is, they should hurry it up. It's been almost a year, and still yet they are yet to pin him down and find him guilty on one or any of the charges. Justice should be granted. On this note, we've come to the end of the news. We say thank you for tuning in to listen. Until I come your way next time, enjoy the rest of your day.